My lord,
Yes.
I'd like to mention also that number 2. We have given the administration yesterday lawsuits. So matter may kind of taken up after 2 weeks lawsuits.
After?
2 weeks. We have taken the concern on the other side of.
Mr. SMT Sisti, Learned Standing Counsel for the Elementary Education Department. With consent from the other side, as for listening the matter after 2 weeks. Fair allowed.
And
What is the reason?
lawsuit, yes, here with the PM Sharma lawsuit, today he was suffering, he has went to cardiologist lawsuit because, so he has already yesterday, he has given some to administrative because he's not well.
lordship, I pray for the petitioner in this matter. Lordship, we have some urgency. Lordship will fix the date. Lordship.
A date may can be fixed. On 23rd February.
Lordship. My lords.
I also like to mention on behalf of the PM Sharma, item number 7, 8 and 9. These are all partner methods where he is repairing lawsuit. So due to his medical illness lawsuit, I the partner side is here lawsuit.
I'm for 7, Lordship. A date may be fixed. Well,
Mr. Sisti also appearing on behalf of Mr. P.N. Sharma, Learned Standing Counsel for the Elementary Education Department. With consent from the other side, press for listing the matter after
2 weeks.
after 2 weeks. Fair allowed, raises all.
Lordship,
List the matter.
Lordship, item number 7 also, Lordship, 12,
12.
Yes.
12.
12 will be too early because but he will be recovered. But 5 is waiting because we think particularly in this because it is part of matter.
Lordship,
That is difficult.
in 8 and 9, the BTC is the main part, the main respondent minor. So.
If they don't have objection, lawsuit,
Okay, 12 then.
yeah.
And item 7?
7 and 23rd.
Take it that for me.
With my lords,
And so far, I have another pair of, so far item number 1, it is also a part of motion matter. Here notice formal notice yet to be issued. We have final referee. So let it, my prayer that let it come for notice should go lawsuit at its lawsuit.
No, direction was to obtain instruction.
Even he had filed a referee also. lawsuit.
My lord, I am for the petition number 1, item 1. my lord.
Item 1.
Item 1. But my instruction is that, my lord, petitioner gathered some information that out of 2 other similar writ petitioners, my lord, one have been appointed by the directorate, my lord, and he is about to collect the copy, my lord. 2 weeks, 1 week time may be granted, my lord, will file reply, my lord.
What
They said that the case is related to other department. Directorate is other, my lord, therefore they are not in a position to reply.
Hmm.
Therefore, my lord, we personally pursue the matter and we have gathered some information that one.
Okay, as agreed by learned advocates of both the parties, recess shall list the matter after 1 week.
Before
After one. No, my lord,
it should go at its.
Lordship may keep it part hard, my lord. Only one date may accommodate, my lord, will submit before the honorable court, my lord, the document. And
What is your pair?
My page is there, the regular, they have to courts are sitting, so the motion is, motion matter not be.
Lordship already heard the matter and it is part hard, my lord. Only one date, my lord, may accommodate, my lord. Part hard matter, my lord.
After 1 week.
Lordship, obliged.
with my lords, so may I mention item 15, 1-5. I may be permitted to withdraw the petition.
Item number 15.
1-5. I may be permitted to withdraw.
Mr. Your name please?
K. Talukdar.
K. Talukdar, Learned Counsel for the petitioner submits that he has the instruction to withdraw this petition. Liberty?
No, it's infructuous. The
Okay.
contract was for 2 years.
Okay.
The contract period is over.
Submits that the matter become infructuous and as such he may be permitted to withdraw the claim. Fair allowed. This writ petition being WPC number 4368 of 2022 stands a disposal on withdrawal.
My lordship, I'm appearing on behalf of Jyotirmoy Roy for the respondent number 3.
Private response.
Okay. Miss, your name please?
T. Saikya.
Please, Learned Counsel appearing on behalf of Mr. Jyotirmoy Roy. Okay.
I'm good.
Made with your lordship. Lordship, I beg to mention item number 7 in lordship. Matter may pass away for the day lordship. We have submitted the adjournment security.
Mr. Bordoloi, Learned Counsel for the
I
petitioner.
was not
Press for
informed
listing the
about this.
matter.
I was not
Lordship,
informed about
I
it.
have taken, I have
Because
submitted.
I am
my-
appearing for the private respondent as legal aid counsel. I was supposed to inform. Last occasion also without informing it was.
Standing also revenue.
Very correct. My consent was not taken. Lord.
You are counsel for the respondent number?
7, my lord.
Respondent number 7. You are legal aid counsel?
Yes, my lord. Otherwise, I do not have any objection, but this type of practice, my lord, should
Lordship,
not.
I have taken consent from the government, Lordship.
But
I have
private
submitted
respondent's
the-
consent is required, my lord.
Next time
Government.
I will take Lordship, but this type of submission should not be made, Lordship. Because I have taken already the consent, Lordship. Probably this time I could not contact him, Lordship. But this type of
Last
submission,
occasion
Lordship,
also same thing
I will
happened.
take consent.
I do not
next
have
time,
an objection
Lordship.
regarding adjournment, but
Regarding practice, this type of submission should not be made in the court.
last occasion I informed the senior counsel regarding this.
Lordship, next week or any date, Lordship.
Okay. With concern from the other side, press for listing the matter after 1 week.
Lordship.
1 week, pair allowed.
If there is a interim order, it's
Interim order passed earlier. Shall continue.
oblige, Lordship.
This is consider the other side. I'd like to mention item number 9 and 10, Lordship.
10 and 11.
Sorry, 10 and 11, my lord. But these matters, my lord, the records were called for, my lord. But unfortunately, my lord, we could not get the records, my lord. So therefore, my lord, the matter may be fixed after 2 weeks. I will in the meantime arrange for the records.
My lord, the same similar pair for the last 3 occasions, this taking for the last thanks may be given for this.
My lord, only,
My lord, I will
I'll just,
we need the records for the proper adjudication.
I'll take 30 seconds, my lord.
Sure.
My friend has came across something to do with dice code in respect of us. We are both the parties in 2 sides. But that is not our case between us, that our name is there in the dice code. I don't know from where he got that one of the parties' name was missing, then it came. If he's asking for the time, my lord, that should be the last step. It is already parted, it's last opportunity. Otherwise, we'll proceed, my lord, because the
Okay,
dice code
okay.
issue is not between the parties.
Mr. Fukon, learned standing counsel for the elementary education department. Press for listing the matter after 2 weeks, as he has not received the record. As per which was directed to be produced before this court. By order dated when?
Last occasion, my lord.
Last occasion, fine. My lord, I am giving minute.
19 and 6.
My lord, there are 6/1, 2020. Yes.
6/1/2026. Pair allowed. Pair allowed. Mr. Fukon is granted the last opportunity to produce the record before this court.
My lord,
Is the matter after?
a date may kindly be fixed being a parted matter.
120.
Deeply obliged, my lord.
My lord, interim order passed earlier.
Interim order pass earlier shall continue.
Deeply obliged.
Deeply obliged.
May please, your lordship. Lordship, I beg to mention item number 38 with the consent of other side. In this.
30,
38, 38.
38.
Yes, lordship. In this case, lordship, they have filed their affidavit. We would like to file our reply, lordship. We have 2 weeks time, lordship.
You are for the petitioner?
Yes, lordship.
Ms. So-and-so, what is your name?
R. Begum.
Ms. R. Begum, learned counsel for the petitioner. Submits that the respondent authorities have filed their affidavit in opposition and the petitioner will file a reply to the same and say price for granting
After 2 weeks, lordship.
2 weeks time. 2 weeks time. Pair allowed, rest shall list the matter after 2 weeks.
Oblige.
May I please, your lordship? Lordship, I beg to mention item number 34. I have already informed the other side, your lordship. This matter will be taken up after 2 weeks, your lordship.
Mr.
I Ahmed.
I Ahmed, learned counsel for the petitioner. With consent from the other side, press for listing the matter after 2 weeks.
2 weeks. your lordship.
Pair allowed.
Deeply obliged.
Lordship, I beg to mention item number 37 from supplementary list, my lord. In this matter, my lord, respondent number 3 have filed 1 affidavit, my lord.
You are for the
Again,
petitioner.
We want to file a reply, my lord.
You are for the petitioner.
I am for the petitioner, my lord.
Mr. Your name, please?
Yes, my lord.
Mr. S. Upadhyay, learned counsel for the petitioner, submits that the respondent number 3 has filed affidavit in opposition and the petitioner will file a reply to the same Any price for granting?
2 weeks time, my lord. 2 weeks time.
2 weeks time. 2 weeks time. Pair allowed. You inform the other side?
I will inform, madam.
No, you first inform. Because later on they will appear and they will raise objection.
No, they have already filed an affidavit, my lord, which we want to file a reply, my lord. That's why.
That's all right. You inform them.
Okay, my lord, I will inform them.
Pair allowed. Recess allays the matter after 2 weeks.
2 weeks. Deeply realized, my lord.
May it please your lordship, I beg to mention item number 27. We need 1 week time to file an affidavit.
Item number 27.
Yes, lordship.
You inform the other side?
No, lordship.
You first inform the other side?
Obliged.
May I please your lordship? Lordship, I beg to mention item number 18. Lordship, to file our affidavit in reply and provide us 2 weeks time.
1/8.
1/8, yes, lordship.
Petitioner will file a reply.
Yes, your lordship.
You are for the
And for the respondent.
respondent. Heard, Mr.
S.K. Lahan on behalf of Mr. N. Bora.
S.K. Lahan, Learned Counsel, appearing on behalf of Mr.
N. Bora.
N. Bora, Learned Counsel for the petitioner, and also heard Mr.
R. Chetri.
R. Setri, Learned Standing Counsel,
On behalf of P. Sharma option.
Learned Counsel, appearing on behalf of Mr.
P. Sharma.
Learned Counsel for the respondent.
AFDC.
Okay. AFDC.
Yes.
FDC. The Learned Counsel appearing for Mr. N. Bora, Learned Conducting Counsel for the petitioner, submits that the respondent authorities have filed affidavit in opposition, and the petitioner will file a reply to the same. Any price for granting?
2 weeks, lordship.
2 weeks. 2 weeks time. Where allowed, recessal is the matter after 2 weeks.
On this.
Yeah, please, your lordship. I beg to mention item number 16, 16.
Yes.
Lordship, matter may be adjourned for today, lordship. My senior is suffering from ailment, lordship.
You are for the petitioner.
Petitioner, yes.
Who is the leading counsel?
B. Haldar.
Miss, your name please?
S. Bosha.
Learned Counsel, appearing on behalf of Mr. B. Halder, Learned Conducting Counsel for the petitioner, submits that Mr. B. Halder, Conducting Counsel for the petitioner, is indisposed of, and as such, she press for listing the matter after
2 weeks, lordship.
2 weeks. Fair allowed.
Obliged.
Items for admission. Item number 12, part of.
Hmm.
And this is regarding my appointment of Anganwadi helper. That is the post, not Anganwadi helper, and it is Badangdunga Anganwadi Center under Lakshmipur ICA. And the first bill kindly see a lordship their annex in a.
Mr. Rasid, the counsel for the respondents are absent. Okay. Can you inform them?
But their names have been shown the note. Both kid.
After some time, the court master will inform.
At 2 PM, some other at the. Sometime I may not.
For time being, not at 2 PM.
Item 14.
None appears for the petitioner on call. None appears for the respondent on call. List the matter after 1 week in the event of subsequent non-representation.
Matter may be passed over for the time being.
Time being.
Yes, your lordship.
Okay.
Item 19.
Lordship, kindly pass over for a time.
Lordship, in this, we have, delivery is ready for sharing, we have sent it for getting. So can we after 2 weeks, Lordship, in this, we file our affidavit on behalf of the state respondent.
Yes.
Affidavit file.
Heard, miss, your name, please? Your name?
D. Swarnalal.
Learned counsel for the petitioner and also heard, Mr.
SR Burua,
S.R. Barua, learned standing counsel.
State Council, Lordship. I am a state council, Lordship, for all the respondents.
Learned state counsel for all the respondents. Mr. Barua submits that the affidavit in opposition has already been prepared and sent for vetting. And he prays for listing the matter after 2 weeks so as to enable him to file the affidavit in opposition. Parallel recessal is the matter after 2 weeks.
Public.
Lordship, Council Mr. S. Botraku is on legs, Lordship. Can you be taken off after some time, Lordship?
Okay.
Number 36. By VC Mohan.
Thirty-six, nine.
And take a part of the Lordship. My is not coming to the PC.
What to do?
So can you pass me the matter for timing?
Timing, okay.
For orders, item 21.
Well, can you peruse the last order dated 15/10/2025? Then next order, my lord, 19/11/2025. And last order is 8/1/2026.
Okay. Mr. Khatania. Khatania মাতি দিব।
Attorney, General.
Item 22. 22.
None appears for the petitioner on call. Lays the matter after 1 week in the event of subsequent non-representation of the petitioner, appropriate order shall follow. Iwapoda? State respondent. Miss, your name please? Miss?
That's additional government.
Miss Eudas, learned additional senior government advocate present. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
23.
Can it be taken up sometime? Okay.
Next.
24. So Lavazima already failed.
Iwapoda?
Against the municipal board law. I will put assume number 1 and 5.
1 to 5.
1 and 5.
1 and 5. But the petitioner is absent. None appears for the petitioner on call. How about Mr. Goswami?
So 1 and 5.
Learned. Standing counsel or government advocate? Government advocate for the respondent number 1 and 5. Present. Place the matter after 1 week in the event of subsequent non-representation of the petitioner, appropriate order shall follow. Next.
25.
None appears for the petitioner on call. Order dated 19/12/2025, passed by the laws in my court indicates that the petitioner remain absent on 19/12/2025. How about Mr. Iwa present here?
5 for 4 and 5.
Mr. Goswami for the respondent number 4 and 5, and you? 2 and 3, present. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
26 and 27.
But I mean, appearing for the applicant, my lord, IN number 3495, my lord. My lord, I have filed, my lord, one, my lord, application for leave to file the review application, my lord. Relevant paragraph, my lord, 5, 6, and 8, my lord.
But they are absent today. After some time?
Yes.
Wait for some time.
My lord, I'm sorry, my lord, he's appearing for, my lord.
Okay, all right.
So I was expecting 1 week time to file an affidavit.
To file
Affidavit.
affidavit.
Yeah.
Who filed the IA?
My lord,
You.
applicant.
Or Mr. A.K. Sharma, learned counsel for the applicant. And Mr. UFO,
I'm representing S.H. Sikdar.
learned counsel for the. Here you are respondent
My lord,
number,
response 7, my lord.
respondent number 7, respondent opposite party number 7. None appears for the rest of the respondent. The learned counsel for the respondent number 7 submits that he may be granted 1 week time to file objection. Fair allowed, recess the matter after 1 week.
My lord, after 13, my lord, I will be out of station next week, my lord.
After
13th,
13.
yes, my lord.
After 2 weeks.
Yes, my lord.
After 13. Date of-
Or 18.
My lord.
18 paragraph.
None appears for the petitioner on call. Office note dated 28/1/2026 indicates that neither AD card nor unserved notice issued to the respondent number 1 and 2 received back by the registry. List the matter after 2 weeks awaiting service report upon respondent number 1 and 2. In the event of subsequent non-representation of the petitioner, appropriate order shall follow. List the matter after 2 weeks.
29.
None appears for the petitioner on call. Office note dated 28/1/2026 indicates that neither AD card nor unserved notice issued to the respondent number 1 and 2 received back by the registry. List the matter after 2 weeks awaiting service report among respondent number 2. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
Permit item 24 admission.
May I please, your lordship? This case, your lordship, we have come against the order of by which your lordship, our bank account has been freezed by the authorities, your lordship. And in fact, your lordship sees the last order, your lordship. We are ready to pay the amount, your lordship, due, your lordship, against this GST default, your lordship. Only thing, your lordship, since all the accounts has been, your lordship, freezed, we are not in a position even to pay, your lordship. So our prayer is, your lordship, we will pay in installment, your lordship, and on that aspect, they are supposed to take instruction, your lordship, GST, council for the GST. And in the meanwhile, your lordship, since if we are to pay, your lordship, that will have to be defreeze, our accounts will also have to be defreezed, your lordship.
Who is supposed to appear for the respondent?
GST councils representing GST, B. Chaudhary, your lordship.
P. Chaudhary.
B. Chaudhary.
P. Chaudhary.
He is coming. Your lordship. Your lordship can peruse the last order. Even otherwise, your lordship, under section 80, there is provision for making payment on installment, your lordship. In your lordship's order is also there, your lordship. To that effect, your lordship.
কবে? B. Chaudhary? B. Chaudhary in B.
Did you?
B. Chaudhary. B. Chaudhary it is standing council. What is?
Did you?
Wait for some time. Let him come.
Lords.
Permit item 23.
Okay.
Your lordship, so far as in আহিলে নেকি instruction?
Yeah.
Here I have received verbal instruction
Number one, Lordship, his GST registration has been cancelled. So to make payment on installment, Lordship, he has to make an application under section 80 before the Commissioner of Taxes. And for that purpose, it's an online process. First of all, GST registration has to be get ordered. And here, and thereafter, Lordship, then only if the Commissioner allows to make an installment of that tax liability, then only Lordship, the difference in that account procedure will be taken up.
Order to deduct. This particular order, your lordship has already quoted section 1880.
So whether you have filed any application before the
No,
commissioner?
your lordship, under
have
not
not
under section 80. Here, your lordship has granted them liberty, your lordship, so far as in this particular case is concerned. Under representations are there, your lordship, not specifically under section 8. Your lordship. Your lordship may grant me liberty, your lordship, so that I can file under it under section 80, and otherwise also, your lordship. In fact, so far as this freezing is concerned, your lordship, that is in violation of the rule 159. Till that, I have not been served with a copy of that order, your lordship, and they have in their affidavit also, they have not said that it has been served on me, your lordship. They have said that it is substantially complied, your lordship. Only that the statement they have made, your lordship. Otherwise, so far as the freezing is concerned, under rule 159, your lordship, they are required to serve the order on me, your lordship. Till that, they have not said whether
No,
that
no,
order is
that is,
there.
that is regarding
Freezing, your lordship.
freezing. No, no. Regarding payment of the amount in installment.
Lordship,
Under
that is,
section 80.
that part is 80, your lordship.
Yes.
Lordship.
But regarding this defreezing of your account, what is your instruction?
Lordship, first of all, his intention has to be there for payment. If the payment and then only the decreasing of the account will be initiated, because if we defreeze it at the earliest, Lordship, without there being any payment, the government will be losing the revenue. Lordship.
No,
Because
that's
first of
all right. If he files an application before the commissioner,
Lordship, it's an online process as per.
yes, we'll grant him liberty to file an application. And on such application being filed, you defreeze the account so that he can make payment.
Lordship.
No, Lordship, first of all, the commissioner has to take a decision whether installment will be, then only Lordship, if he makes at least.
Yes,
one payment
section
of-
80 is there.
one
Commissioner
payment
has to
also,
consider the
Lordship,
thing.
because continuously he has not filed his return, not the whatever liability is there, he has paid. Because his action reflects a different way, Lordship. It doesn't show his intention to make the revenue.
No, no. Now, Mr. Chaudhary, you say now if the petitioner files an application to the commissioner for allowing him to make payment in installment, then unless and until you defreeze the account, from where he will make payment?
Lordship, the defreezing order has to be also from the commissioner as per the act, Lordship.
That's all right.
It's up to the commission, but Lordship, to make the application online also, he has to go through his ID number. And since his GST registration has been cancelled, Lordship, first of all, the GST registration has to be revoked.
Restored.
Yes, restored. And secondly, and that is also subject to payment. And Lordship, and the limitation has already exceeded. It's of 2021. Cancellation of GST registration is of 2021, Lordship.
No,
Yes, made an appeal
No,
for
no.
cancellation as per the revocation of the cancel as per the act, Lordship.
Lordship will kindly see your lordship. They are concerned with the money. I am making a solemn
Lordship, even
promise.
then it's a duty upon him, Lordship,
Let me submit.
to make the.
One by one, okay, let us
Lordship.
compare, yes.
Lordship, they want the money. I am ready to pay. Only prayer is that it should be on the basis of installment. By freezing my account, they will not get the money, your lordship. They want money. I am ready to pay, and that's a solemn promise made before this honorable court. What more can we show our intention, your lordship? Once they defreeze the amount, we will pay certain amount, and thereafter they will. We will also file an application under section 80, your lordship. Till that they have not even served the order of freezing, your lordship. My account and all accounts,
Email account.
all
Lordship,
my
it's sent to the
accounts,
email, Lordship.
all my accounts, your lordship, every account, my wife's account, my account, your lordship, business farms, cash credit account, everything has been freezed, your lordship. Where from I will pay, your lordship. Only thing, your lordship, we will pay. We will also submit an application under section 80, or as your lordship should give a liberty, they should defreeze it. We will immediately make certain amount, your lordship, amount as payment. Your
What is the outstanding amount?
in the, so far as the freezing is concerned, till that date, your lordship, it was 76 lakhs, your lordship. They have, your lordship, in the tabular form I have given from 2018-19 to 2024-25, the amount they have given is 1,76,35,201 euros. 1 crore, your lordship. 1 crore 76 lakhs 35,201. Some amount in the meanwhile we have paid, your lordship, around 6 lakhs something, your lordship.
By Shalan, 11 lakhs.
And by 11 lakhs, your lordship, by Salan, your lordship.
Yes, Mr. Sodhuri.
Your
Unless the account is defreeze, from where he will make payment?
Lordship, that's
Lordship, he will have to make, because first of all, to defreeze the account or to make an application, Lordship, first step is the restoration of the Lordship make direct for restoration. Thereafter only he will have to make the payment, then only the, as decided by the commissioner, then only the defreezing will start.
your lordship says a 226 court, your lordships can always direct probably.
But
your
there
lordship.
is statutory
This,
limitation.
the majesty of this
the
court
act,
is,
Lordship.
majesty of this court is above everything, your lordship.
It's incumbent upon the SSE to fulfill the requirement of the act, Lordship.
Are we done? Order would yes. There are other order also, your lordship, by coordinate bench has passed, your lordship. In line with what your lordship has already held. Did you? Up to 18 installment, your lordship has been granted, and they can give 24 installment, your lordship.
Mr. Bortakor, whether you have filed any application for restoration of the
Your lordship will kindly,
Registration.
lordship has.
May I please your lordship?
Your lordship will kindly come to page 113. This is prayer for deep freezing, your lords.
Principal Commissioner.
Page 113, your lords.
Yes.
And also 120, your lordship, for deep freezing.
No, for restoration of your registration, whether you have filed any application.
Then it will be in the next step, your lordship. That for restoration, your lordship, I have not filed, your lordship.
No, as submitted by Mr. Sodhuri,
Section
first,
8.
you have to file application
I
for
will, your lordship.
restoration.
I will, your lordship. Your lordship will grant me liberty, your lordship, I will file. And two applications for deep freezing has already been pending before them. They have not passed any order in this.
Yes, Mr. Sodhuri.
The lordship can direct for revocation of the GST,
Yes.
cancellation of the GST registration, because already the limitation has expired, lordship. First of all, only 30 days for revocation, then he can make an appeal under section 107.
No, that application is already pending.
No, 107, he has not filing appeal.
Appeal, I have not filed.
That
No,
limitation
the-
has also gone, lordship.
No, the application for defreezing the bank account, that is pending.
Defreezing lordship, under rule 159, he can file an objection within 7 days. That also he has not done. Now lordship can, since he is ready to make the payment, lordship can direct for revocation of the cancellation. Then only lordship he will get his ID, and through that ID he has to make submit his returns, up to date return till the date of cancellation. And thereafter, lordship, he has to make an application before commissioner under section 80 for making the payment in installment. Then only lordship, if whatever decision the commissioner takes, he can make payment, and simultaneously commissioner will also have to take a decision for decreasing, if taking into consideration his earlier representation for decreasing, lordship.
So the
First step, lordship, GST registration has to be
revoked. Okay. Thereafter, he will file his return, and thereafter he will file an application under section 80 for granting him, no, for allowing him to make payment in installment. And if that application is allowed, then he will file another application for defreezing the bank account. And thereafter,
Everything has to be done in the online process.
yes, he will do it.
Lordship may fix a time period for completing the exercise, whole exercise.
Yes, Mr. Bortagar.
Lordship, that's what has been submitted by my line. It is fair, your lordship. Your lordship may kindly come to 107, your lordship, page number
107.
7.
Yes.
These are your lordship challenge against your lordship return we have filed, your lordship. Up to the date of cancellation of the GST, your lordship, that we have already filed, your lordship, uploaded in the portal.
Whatever lordship payment has, that will be adjusted against his liability, lordship. Whatever payment, that calculation, lordship, he has to do, so it needs a return, lordship.
Just go to your.
Okay, then now we are closing this petition.
Lords,
And time frame, within 1 week, you have to file application there for revocation of the order of cancellation.
Lordship,
1 week.
1 week, within 1 week, we will file it.
Okay. And Mr. Sodori, you have to complete the process within
Thereafter, Lordship may on give a time frame, any time frame, Lordship.
2 weeks.
Yes.
2 weeks.
Oh. 2 weeks of the process. to
Okay.
complete.
We are closing this petition.
Ami effect have been. But order of payment. That installment part, your lordship will kindly mention.
Installment part, yes, under section 80,
80,
you will
yeah.
consider.
Lord,
Yes, Lordship.
Lord, deeply obliged.
Yes.
Instruction. This matter for payment method.
How many days?
According to them, this month may this matter take after.
After a week.
Yes,
After a week.
they continuously taken time, my lord, in this matter.
Not
67, one.
Last time when they are requested to find a break down level code and stick to 3 for complete compliance of the order.
Okay, 2-3 days time
Yes,
only.
yes, madam.
Heard Mr. Islam.
Madam, matter may take-
For the petition.
After a quick matter may take up.
Okay, and also heard Ms. Sotia, learned standing counsel, no, learned counsel for the contempt. Ms. Sotia has produced one letter of the Deputy Secretary to the Government of Assam dated 3/2/2026. And on the basis of the said letter, Ms. Sotia submits that the matter may be listed after a week as efforts are being made for making payment of the amount which the petitioners are entitled to. We are allowed to shall list the matter on Monday, next Monday, 16.
16.
The letter produced before the court today shall be marked as Annexure A and be taken to the record.
Much obliged.
May I please, your lordship? I am sorry, my lord. Item number 20 and 29, my lord. I missed the item, my lord. Service 28 and 29. Service is awarded, my lord. I will take fresh steps, my lord. With speed post.
A
my lord.
letter on Mr. Your name?
Esar Ahmed.
Esar Ahmed, learned counsel for the petitioner appeared. So perhaps we have fixed the matter after a week.
I will take fresh steps, otherwise with speed post, my lord. Nowadays, speed post is, my lord. That will.
Uh,
be my lord.
Again, you take down, learned counsel for the petitioner submits that he may be allowed to take fresh step upon the respondent number 1 and 2.
My lord.
Respondent number 1 and 2. They are allowed. Step be taken by speed post and also by usual process within 3 working days from today. List the matter after 4 weeks,
3 weeks.
3 weeks.
Obliged, my lord.
Pending item 23 for audio. May I please? In this case, although my lord, as per last order, my lord, it is not directed to take phase system, my lord. However, my lord, as per order dated 3/12/2025, already my lord service completed, my lord. Last occasion, my lord, due to inverted of the council, it failed to point out this order.
As per order,
Or there is a Lawajima court order 3/12/2025. Kindly pay with it. This is the my lord, in the new address, the service is completed. 3/12/2025.
heard Mr. Gogoi, learned counsel for the petitioner. Mr. Gogoi, referring to the order dated 3/12/2025, passed by the Lawajima court, submits that service upon respondent number 3 is completed. But the respondent number 3 remain unrepresented today. List the matter after 1 week
Looks
for
admission.
admission hearing.
Looks.
There is an interim order, my lord.
Interim order pass earlier and continue.
Deeply obliged.
Wait, please, Lordship.
I was directed to obtain instruction, but that we already been communicated. But the deal is we have not received any instruction.
Lordship,
Okay.
it's been more than three years. Since order dated 7/12/22, the Revenue Department was directed.
More than 3 years.
Last order was 21/4/23, my lord, it was communicated on lordship 24/4/2023.
Heard Miss
V.
learned counsel for the petitioner, and also heard Mr. Zahandik, learned standing counsel,
Lordship Revenue.
standing counsel, Revenue Department, being respondent number 2, 3, and 4.
No, lordship, I am for one only.
Respondent number 1. Mr. Roy for
2, 3, and 4.
2, 3, and 4. 2, 3, and 4. Mr. Hendrik, learned standing counsel for the Revenue Department, submits that the order dated 21/4/2023 has been communicated to the respondent authority, but he has not received any instruction. Any place for granting him 1 week or 2 weeks?
3 lordship.
3 weeks. 3 weeks time to obtain necessary instruction. Not to receive necessary instruction, pair allowed, recessal list the
Lordship,
matter
last
on
opportunity may be given. Last opportunity may be given.
27 February. Since this matter is pending from the year 2014, Mr. Hendrik, learned standing counsel, shall invariably receive instruction on next date, and receive instruction and place the same before this court on next date. List on 27 February.
Obliged.
Number 30.
Maybe lordship. Lordship, in this last occasion, my lord, the
Lordship, you need some time to file our affidavit of pollution, my lord. I'm for the respondent 5, my lord. I still my lord.
You have already granted 2 weeks time.
My lord, we did not get the instruction so that we can file in line. So, another 2 weeks time may be given us, my lord.
Heard Mr. Mubarak, learned counsel for the petitioner. And also heard Mr. Your good name, please?
Vinod Baswar.
Vinod Baswar.
On behalf
Learned
of
standing counsel for the respondent number 5. Mr. Goswami for Mr. Jay Hendik for respondent number 4. Mr. Goswami for respondent number
3 and 4.
3 and 4. 3 and 4.
Sorry.
The learned
1, 3 and 4.
1, 3, and 4. Mr. Baswar, learned standing counsel for the respondent number 5, submits that he may be granted another
On behalf of my senior Ndeka, my lord, I'm doing that.
senior
Ndeka, my lord.
and Deca. Praise for listing the matter after
2 weeks, my lord.
2 weeks, so as to enable him to file the counter affidavit. Pair allowed or SSL list the matter on
lordship, there's interim, my lord.
interim order pass earlier shall continue.
Wait, please, my lord. And pardon me, my lord, I was late by just one item 22, my lord. Today's this 22 admission. It's non-appearance, my lord. I was just late by just 1 minute, my lord. When 23 was called, I was.
You are for
I'm for the petitioner, my lord.
petitioner.
I just.
Your name, please?
D Sinha, my lord.
Okay,
Yes.
later on, Ms. D. Sinha, learned counsel for the petitioner.
Rejoinder of the. I could not obtain
Appeared.
the signature, my lord.
List after? After 1 week.
Deeply obliged, my lord.
Then 31.
Petitioner. petitioner.
Transfer is coming after some time.
Okay.
32.
No, please, Lordship. Lordship, in this case, I have filed one IA, Lordship. IA number 14126, Lordship. For impleading Lord, the opposite party, the respondent, Lordship, in that case. Opposite parties were the members of SLC state level committee, Lordship, for completion and appointment. Lordship, what happened, Lordship? In this case, the case of the petitioner was earlier rejected by the SLC for overage and under qualification. Lordship. So can we, Lordship, page 15, paragraph 15. Considering the provision laid down in the office memorandum so noted above, the impugned decision of the state level committee for compulsory amendment rejecting the case of the petitioner for her compulsory appointment in terms of office memorandum in its meeting held on 4/1/20 on the ground of overage and under qualifications for the post of hereby rejected and quashed. So that overage that also part is quashed by the court and directed to relax the age of the petitioner and direct appoint her to a guilty post. Now they have again during pendency of this condemnation, they held a meeting of SLC and again rejected the case of the petition on the ground of overage.
In that circumstances, the petitioner may challenge the order, my lord, in a district court, my lord. And moreover, my lord, we have filed our IA because of recall or dismiss the personal appearance of the my lord contemnor Narayanpur, my lord.
That is his part, one part, his part for Narayanpur only.
Because by the SLC and SLC has rejected the matter of the petitioner, my lord. So if he has a grievances, my lord, then he may go to the district court, my lord.
He may instruct Lordship, if I challenge that order, he may silence Lordship, if I challenge this order, what order court may pass? Kindly instruct suggest the court. What order court to the court again have to set aside that order, Lordship, and direct the authority to appoint the petitioner to a get again. This is not, that is also barred by res judicata by principle of res judicata. So here specific direction to relax the as paragraph 16. The Secretary of Government of Assam in the Department of School Education shall place the case of the petitioner before the next meeting for SLC compensation of a phrase for her compensation appointment. Considering her elevating grade 3 post, so Assam, relaxing her overage at the time of application. So there are specific direction to relax the age. Though they have not filed any appeal or review, Lordship. If there is no appeal or review, they are bound to follow the direction of the court, Lordship. So they cannot reject the case again on the ground of.
Mr. Sharma, you say you filed this petition, interlocutory application for impleading this 6 person as opposite party.
Lordship. These are the members of the SLC, Lordship. State level committee.
But in the writ petition, whether direction was issued to the SLC?
Lordship. Lordship.
In the writ petition, direction was issued to whom? Who is to carry out the order?
His court already, Lordship, directed to relax the age, Lordship. They have not.
Direction was issued to whom?
Direction was to SLC, Lordship. SLC is the competent authority to relax the age, Lordship, as per clause 16 of the
Direction was issued to the SLC.
SLC, Lordship.
Is it?
Lordship.
You show
Yes,
me the order.
paragraph 16, Lordship, of the order. Of the writ court order, Lordship, at paragraph 15, page 15. So court set aside the decision of the SLC for not giving age relaxation and under qualification. That decision was set aside by the court. Accordingly, directed paragraph 16, directional paragraph 16, Lordship. At page 50. The Secretary to the State Government of Assam in the Department of School Education shall place the case of the petitioner before the next meeting of the SLC for compassionate appointment afresh for her appointment, considering her eligibility in a gazetted post being a master degree holder in Assam, relaxing her overage at the time of her application for.
Where is the order? Page number?
Lordship, order started page 12 and operative part of page 15, Lord.
No, in your contempt petition, page number?
Or, yes, Lord, my contempt petition.
Page number?
Page number, Lordship, 15.
No, in your contempt petition, page number
No, no,
15 is
my
annexure 2.
my impleading petition, Lord. Sorry, Lord. I am going to impleading petition. In my contempt petition, Lordship. In my contempt petition, Lordship, at page 59, order started page 59. And operative part at page 62, Lord.
No, in the writ petition, direction was issued to the secretary. And secretary has placed the matter before the SLC. SLC has rejected the same. So whether the SLC can be implemented here as party now.
Yes, Lordship, because Lordship, the SLC earlier decision for rejecting the case of the petitioner on the ground of overage and underqualification was set aside by this court at paragraph 15. So now they again taken that principle, Lordship. When their decision was set aside by the court, how they can again, Lordship, reject the case of the petition on the same ground, Lordship?
Regarding the paragraph 50, considering the provisions laid down the office memorandum number ABP 50/2006 PT-182 dated 1/6/2015. My lord, in this context, kindly come to the paragraph 8. Paragraph 8 of the order. The provisions of the office memorandum number ABP 50/2006 PT-182 dated 1/6/2015 issued by the Department of Personnel Government of Assam is applicable regarding the consideration of the case of the petitioner for her compulsory appointment under dying harness scheme of the state. Clause 16 of office memorandum stipulates as follows: the upper limit should be relaxed wherever found to be necessary as per the existing government policy. The lower limit shall, however, in no case be relaxed below 18 years. As eligibility shall be determined with reference to the date of the application and not the date of appointment. The state level committee shall be competent to grant the relaxation of upper age limit for making such appointment as per existing government policy. And my lord, here authority rejected his case, my lord. Or here, my lord, wherever found to be necessary, it is mentioned here.
So Sharma, you have received this copy,
No, my. Yeah.
this
There was
application?
approval. Yes.
So in implementing petition, lordship, they are not the necessary to serve the petition lordship. That's because these are the new party lordship.
No.
If lordship implement them, then only I will lordship send copy to them. They are not the engaged advocate of this opposite party or which I lordship make petition to implement. So unless and until this person appoint him lordship, I have to not required to submit furnish any copy.
Direction was to the secretary. Accordingly, they, in the contact with them, they have made the party the contempt of Narayan for secretary. So my lord, now they are including another parties.
So Mr. Sharma, you say direction was in the rate petition, direction was issued to the secretary
Secretary.
to place the matter before the SLC.
SLC.
he has accordingly placed the matter before the SLC. And SLC has rejected your pair.
Lordship. Lordship, second part is there, Lordship. SLC for competition upon F3 for her competition upon considering her eligibility in any grade 3 post, being a master degree holder in Assam, relaxing her overage at the time of her application at the time of competition. So there is direction to relax
No,
her
Mr.
age.
Sharma, you say whether this direction was to the SLC or to the secretary.
So, Lordship, as per office memorandum, power is before the SLC to relax the age, Lordship. So it is the SLC to relax her age, Lordship. Yes, because as at paragraph 15, earlier decision was set aside, Lordship. They cannot reject the case of the petitioner again on the ground of Lordship overage, Lordship.
So, my lord, there are basically benches for SLC decision, my lord. So, my lord, secretary is no responsible here and no rules. He has to place the matter before the SLC and accordingly SLC decide that. So, my lord, matter is complied and matter may be closed and he may.
No, Lordship, he has secretary has still that. Even after 2 years, he has not filed the affidavit in the case. Only placed the instruction before the court, Lordship. In a contempt proceeding, he has not filed the affidavit till that, Lordship. He is trying to pray that he may be Lordship.
So now he has placed before the court the compliance order. So, Mr. Sharma, you see whether any purpose will be served by impleading the members of the SLC in this contempt proceeding or not, because the direction was issued to the secretary. Secretary has accordingly placed the matter before the SLC. SLC has rejected the same.
So this is the only way to give
You see,
relief to
Mr.
the
Sharma,
petitioner.
the members of the SLC were not party in the writ proceeding.
So directions were, Lordship, to SLC, Lordship, to elect the age. So if they not elect, the other authority cannot elect, Lordship.
That is there, but if we implement them, they will take a plea that since they are not a party in this writ proceeding, they are not bound by this order of this court.
No, no, Lordship. SLC was the party, Lordship.
Where? In the writ petition?
Respondent was full, Lordship.
In the writ petition?
Represented by the Chief Secretary.
No, in the writ petition.
In my at order itself,
State
Lordship,
level committee.
respondent 4.
Yes, so Mr. Sharma, the SLC is the party. Respondent number 4 in the writ proceeding.
Direction was given to the secretary to place the matter before the SLC. And thereafter, SLC decided and rejected the matter. So, my lord, it is SLC's own decision. My lord. So
Maybe, since SLC was a party,
but in the contempt petition, they are not party.
no, in the writ petition.
Petition, they are party, and after deciding the
If Mr. Sharma, you see, if as per the memorandum, the SLC has to condone the SLC has to relax the age, overage.
Yes.
Then whether it can be said that the SLC has complied with the direction issued by this court?
It was.
You show me the memorandum.
As per office memorandum, it is as per the existing government policy, madam. And they have rejected it as per government policy.
Page, Lordship, 62 relevant part of the office has been, Lordship, quoted. But I have not annexed the office memorandum with this contempt petition, Lordship. That was in the writ petition. I have, Lordship, that.
So, the secretary has complied the order, my lord, here.
No, SLC is not a party in the contempt proceeding. Now he pressed for impleading them. Is there any bar in impleading them?
But my lord, one thing is that their direction was given by the honorable court to the secretary, my lord.
Maybe. If the power is with the SLC, then to relax the overage.
He may file another requisition and.
No, no, no.
By alleging all this, my lord.
No.
Making statement against the.
Which is the relevant column?
Paragraph looks at 16, para 16 of that memorandum.
And what is the existing government policy?
Lordship, now they have adopted one policy lordship after 2016 or 17.
Mm.
That this family will get the full salary of the employee lordship at the time of death. But neither that lordship benefit has been given to me, nor I have been appointed lordship.
No,
I was
whether
given
you
only
have
the
receiving that benefit.
family pension lordship.
You have receiving that.
Which is half to the lordship salary, and as per order, that amount also is going to be half again in this year lordship, 2026. Lordship, if the state level committee come and say that yes, that is, so this is the only way lordship to give relief to the petitioner.
No, in which part of this memorandum it is stated that the state level committee has the power to relax?
Lordship.
Where it is stated?
It's lordship, clause 16 lordship. Last line.
Okay. Last line.
Last sentence. Lordship. What they have taken lordship after placing this case before SLC, they again send back to the personal department. Whether they have the power to give relaxation lordship. Only way to delay the matter. Now they have taken the plea that the matter is delayed. Now we cannot relax the.
Okay. Heard. Mr. E. Sharma, learned counsel for the applicant. This interlocutory application is preferred by the applicant for impleading the opposite parties, namely Dr. Robbie Kutta, Chief Secretary to the Government of Assam, Sri M.S. Mani Bhannan, IAS, Commissioner and Secretary to the Government of Assam Personnel Department, and Srimati Malavika Chaudhary, IAS, Secretary to the Government of Assam Finance Department, Sri B. Chakraborty, LRN Secretary to the Government of Assam Judicial Department, Sri Shahnawaz Chaudhary, IAS Secretary to the Government of Assam Department of School Education, and Sri Rup Kumar Rabha, Deputy Secretary to the Government of Assam Personnel Department, as opposite party number, as respondent number 2, 3, 4, 5, 6, and 7 in the contempt proceeding, being contempt petition, the contempt within bracket civil petition number 576 of 2024. 2024. Mr. Sharma, learned counsel for the petitioner. No, for the applicant, submits that this court, while disposing of the writ petition dated, writ petition number
Everyone 7/5/2022.
7175 of 2022, White order dated 28/4/2023 was placed to direct. Now, in paragraph number 16, was pleased to direct the secretary to the Governor of Assam in the Department of School Education to place the case of the petitioner before the next meeting of SLC for compassionate appointment if fresh for her compassionate appointment. Considering her eligibility in grade 3 post, being a master degree holder in Assamese, relaxing her overage at the time of her application for compassionate appointment in terms of clause 16 of the OM dated 1/6/2015. Noted above as applicable. Further, referring to the office memorandum dated 1st of June 2015, Mr. Sharma submits that as per clause 16 of the said OM, the state level committee shall be the competent to grant relaxation of upper age limit for making such appointment as per existing government policy. But as per direction of this court in the order dated 28/4/2023, the secretary to the government of Assam has placed the matter of the petitioner before the SLC. But the SLC, without taking note of the direction issued by this court in paragraph number 16 of the order dated 28/4/2023, again rejected the claim of the petitioner. And as such, the members of the SLC, as mentioned herein above, are required to be implemented as respondent in the contempt proceeding number 576 of 2024. And under such circumstances, he has contended to allow this application. Further, having heard the submission of Mr. Sharma, learned counsel for the applicant, I have carefully gone through the petition, the application and the documents placed on record, and also perused the order of this court dated 28 and also the OM dated 1st June 2015. 1st June 2015, and also the order, also the minutes of the meeting of the SLC dated. What is the date of the SLC?
31/10/2031,
31/10/2025. 2025.
Yes, 17. Lord.
And it appears that the SLC has again dismissed the case of the petitioner. Under such circumstances, this court find sufficient force in this application, and accordingly the same stands allowed. Let Dr. Robbie Kutta, number 1 to 6, be implemented as a respondent in the contempt case number 576 of 2024. In view of the order passed in this IA, Mr. Sharma, learned counsel for the applicant, shall file amended cause title in the contempt case number 576 of 2024 within a period of 1 week from today. 1 week from today. In the other IA, you have received a copy?
Lordship.
Heard Mr. U. Sharma, learned counsel for the applicant. And also heard Mr. P. Sharma, learned counsel for the respondent. This interlocutory application is prepared by the applicant for recalling or dispensing with the personal appearance of the respondent contender as directed by this court by order dated 17/12/2025 and 2/12/2025, passed in contempt case number 576 of 2024. Mr. Sharma, learned counsel for the applicant, submits that as per direction of this court, in WPC number 7175 of 2022, by order dated 28/4/2023, the matter of the petitioner was placed before the SLC by the contender on
31/10/2025.
31/10/2025, and the SLC has dismissed the claim of the petitioner. And as such, the direction issued by this court to the secretary struck contender has been complied with, and under such circumstances, his personal appearance before this court may be dispensed with.
Yeah.
May be dispensed with. Yes, what is your submission?
Lordship, in this case, I have no objection to.
Mr. Sharma, learned counsel for the opposite party, however, submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed, dispensing with the personal appearance of the secretary struck contender before this court. Until further order.
Lordship, only one lordship.
In terms of this, I stands disposal. Yes.
Secretary has already complied the order and accordingly.
We'll see later on, but time being, you have been dispensed with.
Yes.
Time being.
Lordship, registry may be direct, in my lordship, lordship, registry may be direct to furnish me the lordship numbers of the register so that I can lordship file that take consignment before the court lordship.
To direct?
Direct registration numbers of my lordship, which I going to be registered lordship to the opposite party.
Okay, you file an application before the registry. Registry will consider the same.
Regarding IA 141/2026 copy has not been up to.
He is not the lordship engaged advocate of this opposite party lordship.
You are not a party.
Yes.
Mr. Sharma, you can take back this memorandum.
If required, also I give one copy will be in the record lordship. This is the.
Time being not necessary.
High level.
We'll resume after 5 minutes. Nine, Board of Secondary Education Assessment.
Here in the case regarding appointment of selection and appointment of Anganwadi helper. Advertisement was issued on Miller 1.
Mr. Roy, you have filed your reply here, affidavit?
Here, my lord, the board has, my lord, I think has no role, my lord, regarding the candidate, my lord.
Board has no rule.
No role.
Now,
Who is for the other department?
My lord, government, my lord.
Government has filed it. Yes.
Who is the conducting counsel for the respondent authorities?
Last time, Mr. P.C. Sudhir is appearing. Now my lawyer has come.
Let the matter come some other day, lordship, because I have not gone through the letter. These three councils are there, lordship.
Who are they?
This is Chutia is not today, lordship.
Okay.
Some other day, Lordship. I'll take it.
You were appearing for respondent number?
I will be waiting for it. For Lordship here. Number 51. 2, 3, 1, 2, 3, 4, and 5.
Some other day means after 1 week?
After
Mr. Rashid, after 1 week then?
My lord, that is, may I
Her-
put that, then 10 or 12, your lordship,
10 or 12?
February.
12, Lordship.
12. Heard Mr. Rashid, learned counsel for the petitioner, Mr. Roy. Learned standing counsel for the respondent number 9. 10. Also, Mr. Roy for the respondent number 1, 2, 3, and 4.
Otherwise, the matter is short and simple.
Mr. Roy, learned counsel for the respondent number 1, 2, 3, and 4. Praise for listing the matter on 12. 12. Parallel races are list the matter on 12.
Part hard is part.
Okay, as part heard.
May appeal lordships. A matter relating to selection and election of the president and vice president of the Gaon Panchayat. In a Gaon Panchayat, my lord. My lord, in this case, my lord, a first meeting held on 10/7/2025 as per section 46 of the constitutional rules, my lord. And in the first meeting, my lord, 10 ward members. Petitioners are the 6 ward members and respondent, my learned friend appears. They are the four ward members. They were present. The authorized officer, my lord, administered the oath, my lord. Thereafter, the petitioner number 6, he has proposed the name of petitioner number 1 as a president, and respondent number 10 proposed the respondent number 8 as a vice president, and petitioner number 5 proposed the name of the petitioner number 2 as a vice president, my lord. Thereafter, the authorized officer, my lord, decided to held election, my lord. In the election, my lord, a petitioner side casted vote in favor of the petitioner number 1. In total vote 6 votes, and 6 votes casted in favor of the petitioner number 2, my lord. But after the completion of the voting, my lord, and the authorized officer arbitrarily declared the respondent number 8 as a president, my lord, in violation of the section 46(6) of the constitution rules, my lord. And petitioners immediately submitted application before the deputy commissioner as per section 11 of the Panchayat Act regarding the anomalies of the selection and president and vice president of the Gaon Panchayat, my lord. That application yet to be disposed of, my lord.
Mr. Ahmed.
My lord.
Yes, you for respondent number?
Yes.
Respondent number 8. And Mr. Roy for respondent number?
Other official respondent. Yes, my lord. Similar facts and circumstances, my lord, learned forwarded bench passed judgment, my lord, and remanded the matter to the deputy commissioner to decided the matter by conducting hearing both the parties, my lord, as per section 11.
Yes.
Yes.
Deputy commissioner.
Yes.
They have to, they have any complaint, they have to absolve the deputy commissioner.
After due opportunity, my lord, both the parties may be heard, my lord, before the deputy commissioner, as per section 11 of the constitution, Panchayat Act.
Where is your representation here?
Yes, my lord. First representation is Pace, my lord.
You file fresh representation, lordship, along with a copy of the.
No, that representation is pending, page 48 and page 44, 44 and 48 page.
Page 48,
44, my lord, first representation on the very day, my lord.
44.
That not difficult. Hearing was already as per my wedding lordship. So I am asking him to file a fresh representation on that. lordship.
Hearing it was na it was
Hearing also taken.
it was hearing one I to my information.
So you will file fresh representation, which you will consider lordship.
Yes, yes,
On the party.
yes, it was it. Did but like it is. Yes,
You will file fresh application.
to my information, Miller, hearing was not concluded.
Concluded.
Yes, not concluded as per my information.
But he filed one affidavit.
Notice was issued, my lord. Notice was issued, but hearing was not held.
Hmm.
As per their affidavit.
So now both the representation are pending before the deputy commissioner. 44 and 48, page
Yes,
number
yes.
44 and 48.
Yes.
So direction is to be disposed of
Yes,
both the representation after affording opportunity of being
Yes,
heard
yes.
to both the parties.
yes, yes.
There is something that paper done. Yes.
Okay. Hmm. So should we fix a definite time within which the representation are to be disposed of?
Yes.
Within 2 weeks from the date of receipt of certified copy of this order?
Yes, yes, yes.
Because the case has to be given for full party.
3 weeks.
Creates a money.
No. He will appear before the deputy commissioner.
Yes, but all the.
He will inform his party.
Not all the.
10 ward members, my lord.
All the board members has to be present, but your notice has to be.
Okay. Okay, within 3 weeks. Okay.
Pending item 36. By VC move.
Complex.
My lords, in this case, I am appearing, my lords.
May I please, Your Lord?
My lords, they are agreed by the order passed by the National Commission, my lord. That is at page, my lord. 109.
Your Lordship, we have initially filed a complaint before the State Commission Guwahati, State Consumer Commission. There, my lord, the order has been, judgment and order has been filed by the order dated, my lord, 5/9/2019, wherein, my lord, court has given compensation for loss caused by the bank for their deficiency in service. Well, because of the theft from the locker, my lord, bank locker. So against that, my lord, the bank, they have preferred appeal before the National Commission. And the National Commission, my lord, has whimsically, my lord, modified that order and reduced the compensation amount to rupees 10 lakhs.
From?
And because, and against that, my lord, I
What
am
was
for-
the amount awarded by the state commission?
State Commission, my lord, it is 23,85,600, my lord. And plus, my lord, separate amount for, my lord, mental agony and, my lord, loss of, my lord, for litigation also, my lord, 10,000. And
Also for my lord, interest
No,
from the date of filing the
the
case, my lord.
National Commission has observed that the compensation awarded by the State Commission is on the higher side.
Higher side, my lord.
So is it not a reason?
That is the, my lord,
My lords are at 227, my lords, and the amount that has been given, my lords, is absolutely more than what was required, my lord. If my lords may kindly refer to the
Mr. Sahewala,
My
let
lords.
the counsel for the petitioner complete
my
first.
lords, my lords, my lords.
Yes.
my lord, this 10 lakh amount, my lord, stating that it is on the higher side, this is given only for the deficiency in service.
Mm.
So for regarding the, my lord, pecuniary loss of my lord, jewelries, my lord, and for my lord, mental agony and all, my lord, that has
Cost of litigation.
the cost of litigation, my lord, no amount has been paid, my lord.
So
Because it is established, my lord, that there is a loss of the loss of jewelries, my lord. And there is deficiency in that, my lord. Bank could not, my lord, given us the security or safety for keeping the jewelries, my lord. That has been established during the course of the case, my lord, during the trial. And after that, my lord, that order has been passed, my lord. And that has been, my lord, without any reason, my lord, that has been come down to 10 lakhs. Only that is for only this compensation of rupees 10 lakhs for deficiency in service on the part of the bank. For the material loss, my lord, and for this mental agony, my lord, this poor National Commission, my lord, has not given any, my lord, compensation, my lord.
Okay. Any other point?
Other things, my lord, the other part, my lord, is that, my lord, whatever amount has been paid, my lord, that has been paid on the basis of the, my lord, the evidences taken by the during the trial, and my lord, on the basis of all this, my lord, that much is my submission. It is much, my lord. So that the amount given by the State Commission is just and fair, my lord. Since 2011, my lord, the case is going on, my lord.
2011,
my lord. And the calculation which I have given for the gold, that was at the rate of that relevant point of time, my lord. That the rate of the gold, my lord, I have given as for claiming the compensation at that relevant point of time was on the basis of the rate of that time, my lord. Now, my lord, the price of gold has come to, my lord, 1,70,000 per 10 gram at present, my lord. And at that time, my lord, it was 6,000, my lord, at the rate of 6,000 rupees per 10 gram, my lord. I have given claimed the compensation, my lord. How can it be, my lord, exorbitant, my lord? And the court has given on the basis of that rate only. Honorable Commission has given the State Commission has given the compensation on the basis of that rate, the rate which I have given claimed I have on the year 2011, my lord. The National Commission also, my lord, has come to the conclusion that, my lord, there is deficiency in service. They have acted, my lord, that has been proved, my lord.
Okay. Any other point?
This much.
Yes, Mr. Sahewala.
My lords, may kindly come up to page 112 of the writ petition, my lords.
Yes.
My first point is, my lords, that the National Commission or the Consumer Forum does not have jurisdiction to decide this matter, my lord. That has already been settled by the Supreme Court. My lords, may kindly read para 16, my lords, at page 112, my lords. That was the reason why the court did not interfere and just said you take 10 lakhs and be happy with that. Because the forum that they triggered was not the actual forum. They should have gone to the civil court to find out what was the loss that has accrued to them. It is not the consumer forum which is going to decide, my lords. My lords, may kindly see para 16, my lords. May I read, my lords? Page 112.
If the national commission is not the proper forum,
My lords.
then how can they reduce the amount to rupees 10 lakhs only?
That is why, that is the reason, my lords, that they have given as the amount they have given at 10 lakhs, my lords.
No, Mr. Sayola, from where you derive that authority to
My
reduce?
lords. Yes, my lord. That is my lord. I'll read out, my lords. Page 112, my lords. Para 16. As regard to the loss on account of contents of the locker, it is settled law of preposition in terms of the decision of Amitabh Dasgupta that the findings regarding the contents of the locker cannot be adjudicated before the consumer fora and must be evaluated by the civil court for proper appreciation of evidence led by the parties. Now, my lords, what had happened in that case, the Supreme Court had directed RBI to make guidelines. My lords, my junior will hand over you the guidelines that was subsequently formulated, my lord. What is the quantum of compensation that a bank is supposed to pay? That is at page 15, my lords.
No, you are not answering my question.
My lords.
If the national commission is not the proper authority, then how you have arrived at the conclusion that rupees 10 lakh will be the proper amount?
No, my lords, we are not challenging that. Otherwise, my lords, we would have filed an appeal against that order. So my only thing is that, my lord, that this quantum that has been given is just, and we have agreed to that. We'll pay to that. As far as the quantum of gold they are concerning, my lord, the gold cannot be quantified by the consumer forum, my lord. That is my submission, my lords. The gold cannot be quantified.
After, Mr. Sayola, you say after making observation in the paragraph number 16,
My lords.
you have reduced the amount to rupees 10 lakhs.
My lords.
So from where you derive the authority?
My lords, then I'll do
why
one.
why the matter was not relegated to the civil court to adjudicate the amount?
Well, I don't know about that, how it was not, but it was observed that it has there for the gold quantum, my lords, they have to go to the civil court to find out what was the quantity of gold. Just alleging before because consumer forum, my lords, you are well aware that there are limited jurisdiction, my lords. So as far as the RBI guidelines are concerned, my lord, if required, we'll file an affidavit bringing in record the RBI guidelines and the statute, so that the court can pass an order, my lord.
No. Now we are testing the order of the National Commission.
Yes, my lord.
Going by the paragraph.
My lords.
17
My
of
lords.
the impugn order, can it
My
be
lords.
said that it withstand the legal scrutiny? In the light of the observation made in the paragraph number 16?
My lords, as far as the quantum of gold and things are there, they have not touched it, my lords. My thing is that the 10 lakhs is also on the higher side. But being a bank, we said that you take that 10 lakhs, will not agitate that matter. Other which ways, it would be right on the bank to file and cross appeal and get it reduced, my lord. Because they say that the locker was never broken, my lords. Locker was never broken.
Then?
It was open, my lord. It was already left open, my lord. I don't know how it happened.
No, you were the custodian.
Yes, my lords.
You were the service provider?
Yes, correct.
Then, is it not deficiency of service?
We absolutely bow down, my lords, that it is the deficiency of service. That is why we are agreeable that this is the amount that we are agreeable to pay. Please take it. Now they come up and say, no, the quantum of gold has not been quantified. My lords, we say that the consumer forum does not have the jurisdiction to decide the quantum of gold. Suppose a person comes up and says, I have 10 kgs of gold in my locker.
No, understood. But how they have reduced the amount from 23 lakhs to rupees 10 lakhs? How they have assessed it? What is the basis of that assessment?
that perhaps, my lord, I'll further take instructions and find out how they have assessed it, my lord. That how they have assessed to 10 lakhs of rupees, my lord. My lord, some other day let it come up. I'll find out how it has come up, my lord.
No. You cannot by way of an affidavit or any other thing can supplement the reason now.
No, correct, my lord.
We have to test the legality of this order
Yes, my lord.
on the basis of on the face of it. On the face of it.
Give me, my lord, give me some time. Let it come up next week or day after, next to next week. I'll give a suitable answer, my lord.
Yes.
Lordship on next Monday.
Monday. Mr. Sayola, can it be on next Monday?
My lords, on 11th, my lord, if possible, my lord.
11th. 11th.
11th or on 17th, 18th, any day.
Okay.
11th.
11th. Heard Mr. U.J. Soikia, learned counsel for the petitioner, and Mr. A.K. Sayola, learned counsel for the respondents. On the pair being made by Mr. Sayola, the matter stands adjourned to be listed on 11th of February as part of.
Grateful, my lord. Grateful.
Item 33.
Here, my lord, one IA has been filed. It is a very unfortunate case, my lord. In this case, my lord, the petitioner, he was originally a landowner of a land measuring 8 bigha, 1 kata 10 lesa, out of which, my lord, 7 bigha, 1 kata 10 lesa, that has been, my lord, given to the petitioner by way of execution of a sale deed by the court itself, my lord, in a execution case. And that land is covered under, my lord, 144, 45 dag number and patta number is 45 of, my lord, the Bhitor City village. What happened, my lord? In the month of, in the year 2023, the land was, my lord, suddenly, my lord, a certain portion of the land was excavated by the respondent number 3 and 4, but without any authority and by way the land was damaged. On that issue, my lord, petitioner has approached before lordship by one writ petition. And during that writ petition, my lord, the another, my lord, the one IA was filed. My lord, that petition after issuing the notice, my lord, they filed the affidavit by respondent number 3, specifically stated that they have not encroached my land, but they have stated that the work has been, my lord, initiated on the basis of the NOC obtained from the, my lord, concerned authority. That after that, my lord, suddenly for some time the land was work was stopped, and again that was started. Initially, they encroached land measuring very limited amount, very 1 kata certain lessons, and subsequently they again, my lord, across my land. It is more than, my lord, 4 bigha land in that time. So then in this, my lord, I have filed another IA, and that in that IA, my lord, that certain, my lord, work was certain for certain period that was stopped. Now, my lord, suddenly that encroached the entire land almost, my lord, the 7 bigha land. Little bit of it has been left out. That will be also, I have been informed, that will be covered. So, my lord, my prayer is this: so far the land is, my lord, encroached by the government. It is my Medipatta land, and moreover, it is from the line of one document I lordship will show. I'll show, my lord, this is an annexure that has been annexure 48 page 88 of my affidavit reply to their counter, my lord, in IA, my lord. That was filed by me. That is on 10/1/2025. It is continuous pagination, my lord, is 88. In earlier occasion, my lord, one I had to face one notice from the this respondent, my lord, 3 and 4, on the issue that I have constructed certain, my lord, factories and other construction on the land without obtaining their NOC. So, and that issue, my lord, I have challenged the notification before your lordship, and after continuing more than 6 years of case in 2 writ petition, ultimately that was decided by the honorable court without interfering in the notice, simply saying that if something is there that I, for classification changing of the land, then I should approach to the authority concerned, and until and unless the decision is taken by the authority concerned, no demolition work will be done. But the accidentally, my lord, the on the day that is on 10/7, that has been land advisory meeting, my lord, that was held on 10/7/2024 in the office chamber of
No,
deputy
Mr.
commissioner.
Thornton, now what is your pair in this IA?
IA is, my lord, that without, my lord, acquiring my land, that flouting the provisions of the, my lord, Fair Compensation Act 2013. So they have occupied, my lord, entire Miadipatta land. So my prayer is this, my lord, until and unless this work is stopped, they are not coming for any compensation or land acquisition process, my lord. I have no objection to take the land by way of a process, but that is not followed. So this is my prayer is that to stop the, my lord, construction till, my lord, they come with a particular land acquisition process, my lord. Because, my lord, my construction is there, my building is there, it is going to be demolished and already is demolished certain portions. It is by way of act of a, my lord, this is eviction notice by lord, respondent authority, that is a development authority, I am not on that. But the remaining portion, that is where they are going to cover my entire land, my lord. It is my Miadipatta land, they cannot take the land in that way. I have no objection if their land is required for the objection, my lord, for the project purpose. It is the name of the project is, my lord, that bank protection of the river Moravuruli from Padwasarili to Kolaguri Viswanatha Prasad Rabha Samadhi. That is phase 1. I have
Okay,
no objection, my lord.
Okay, who is for the respondent?
Number 3.
Respondent number 3. Okay.
But in our affidavit, we have stated that, that we have not acquired any land of the petitioner. So whatever he is saying that the entire land has been acquired, forcibly occupied and excavated. So these are not accepted and these are highly disputed questions of fact which cannot be adjudicated here in the proceeding.
No, madam, you see, this interlocutory application is filed for staying the ongoing project.
But how can a project be stopped like that? If we have on record, we have said that we have not encroached upon petitioner's land. I'll file my affidavit if your lordship requests because this has come for first time. But in the
No, this is not the first time.
we have already taken a stand that we have not encroached upon the land of the petitioner. No land of the petitioner has been acquired.
In our affidavit also, lordship, it has been stated that no land of the petitioner has been
Actually,
acquired. Like how many land?
he should seek a declaration of his title, my lord, in this will. Because we are saying that there is no acquired encroachment of the petitioner's land.
Okay, you file objection here, we'll see.
My lord, one thing, my lord. In the same way, they are saying that they have not encroached my land, but they have said that their NOC has been obtained, my lord. But they have not produced the NOC till today here. First of all. Second thing, my lord, let me finish. Let me finish. Mr. Roy, let me finish. And second thing, my lord, the document I am showing you, lordship, 88 page, my lord. Why T6 scam? Now they are saying that my land title should be proved. It is already executed by the court, my lord. This is given by the court, civil court, not by any process of purchasement I did. It was executed by the civil Nazir in a process of, my lord, the suit, where, my lord, I have been decreed the land in my favor, and civil Nazir himself came forward to execute the land in my favor and handed the possession in presence of the land bundle and everything. And earlier occasion, I have stated that, my lord, they have issued the notice on the ground that this is my land, Bautoli. This is Bautoli land, Miadipatta land, but this is not only for the construction of the building and any other purpose. So that issue, it has been decided by the Honorable Court. In that time, this same authority never saying that if this land belongs to the government land. The same authority. They contested the case all along, 6 years. Nowhere they have whispered. But now they are saying that this is a government land, they are not encroached my land, but NOC is there. So where is the NOC, my lord? Let them produce the NOC. In the same affidavit they are saying, I also reiterated the same thing in my writ petition, in I also. And this is the, my lord, kindly see, this is a kindly, my lord, for a moment, my lord. Page number 88, my lord. For a moment, my lord.
Page number?
88, my lord. Annex of 4 of my reply.
Yes.
It is, my lord, minute of the district level committee meeting regarding this declaration of the reclarification of the land held on 10/7/2024 at 10:01 AM in the conference hall of the office of the Deputy Commissioner Sonitpur, my lord, where my lord, the kindly see Sri Devakumar Mishra, ACS District Commissioner Sonitpur, Tezpur, presided over the meeting. At the outset, they welcome all the members of the present in the meeting. The meeting in convent regarding the reclassification of the land at Sonitpur district. The following classification has been taken up as option in the meeting. Number one, my lord, the Mazhar Sultan. This is a petitioner before lordship. Kindly see the district decision taken, my lord. The other side, the committee discussed the proposal submitted by the circle officer, Tezpur Revenue Circle, the joint verification report submitted by the chairman, Tezpur Development Authority. Number two, district agricultural officer, Sonitpur. Then number is general manager, DIC, Sonitpur, Tezpur. Then number four, executive engineer, water resource department, Sonitpur, Tezpur, district project officer, DDMA, Sonitpur, Tezpur, circle office, Tezpur. As per the report of the executive engineer, water resources department, Sonitpur stated that due to it is not well eligible. The flood inundated and the erosion water resources department has adopted a protective measure on the bank, Moravareli River, and the land adjacent to it is in possession by the applicant, that is Mazhar Sultan. They may hamper any anti-erosion measure to be undertaken by the water resource department in the future if the land is classified as commercial purpose, my lord. As per the report of the DDMA, Sonitpur, Tezpur stated that the section 30 of the Disaster Management Act, the scheduled area will be identified as a vulnerable to disaster. So as the proposed land should not be used for the commercial purposes and subsequently preventive measure for protection of the river bank is a utmost priority. As per this GMDIC report stated that the land is not feasible for any industrial purposes. However, an ice factory and other ancillary structures are seen in the scheduled land, which is affected the natural flow of the water of the Moravareli River. As per the report, Chairman Tezpur Development Authority stated that the applicant, Mr. Mazhar Sultan, has constructed the ice factory and the ancillary structure illegally without any valid permission from the concerned authority. Considering all this fact and probability of the matter, they also seen the discussion relevant report, joint verification report, etc. The committee is decided not to recommend the reclassification proposal as applied by the Muhammad Mazhar Sultan, and from this detail virtuosity to commercial industrial classification land. So, my lord, from this it is clear the land is, my lord, this is my belonging land, is a Medipatta land. Only, my lord, the impediment was there that this is a boundary land, this is not a commercial, cannot be converted, and they say that certain embankment process is going on. So if it is commercial, then that may be affected. That must only, my lord. But this is nowhere it is stated, this is a government land, my lord. So my report, my lord, my pair, but they should bring this all the, my lord, reports submitted by the all the concerned officer.
Mr. Monto,
Itself,
let them file their objection.
my lord, but I have no objection. My lord, no construction, my lord, because, my lord, they have entire land has been occupied by me, them. This is my Medipatta land. What right they have? They given by the act provisions. Why 11, 12, it is not followed, my lord? They should issue the notification before that. They go for the acquisition process, assess the value,
No,
give me the value.
Mr. Monto, let them file their objection. We'll consider your pair on next date.
My lord. But at a limited time will be given, my lord, because we unnecessarily they are going on delaying the entire.
Because staying a project is a.
No, I am not against, my lord. I am not against the project. They can go for the project, but with the process, my lord. What is the process? If somebody private is entered in a private land, it is a land grabber, my lord. The government is doing the same thing, like one and what we, my lord, name in the government. Same procedure, my lord.
Okay. Madam, within 1 week you file your objection, we'll say. No, not 2 weeks. Because
it's a long
time
day,
is
madam.
going.
10 days at least.
10 days will be too long, no? 1 week will be sufficient, right?
Sufficient, my lord. 10 days, my lord, at least 10 days.
Heard Mr. Monto, Learned Counsel for the applicant. and Ms. P. Chakraborty, learned counsel for the standing counsel for the respondent number 3. Mr. Roy for respondent number 2 and 5. 2 and 5. This interlocutory application is preferred by the applicant for temporarily staying the ongoing project renamed as Bank Protection of River Mora Bharoli from Porua Sareli to Kolaguru Bisnurava Samadhi within bracket phase 1 until and unless just compensation is decided or given to the petitioner by the competent authority on acquiring the petitioner land by the government for execution of the said project. Ms. Chakraborty, learned counsel for the respondent number 3, submits that she may be granted at least 10 days time to file objection. Where is allowed recess and lays the matter on.
My lord, one prayer, my lord, by another my lord order that is in main WPC, my lord, the director of the survey that was made party as a respondent 6, my lord. Notice probably not issued, my lord. On respondent number 6, that may be.
Okay,
issued.
we'll say, any objection on fixing the matter on 16?
No.
Yes, you are for? Respondent
you are,
number
no?
6.
Pretty file question, my lord.
In the main petition.
Main petition, my lord.
Okay. Okay.
And one mistake also, my lord, I may be allowed to, my lord, the amended constitution regarding, my lord, the director of land survey, he was not made party in the IA, my lord. I may be allowed to, my lord, impede him, my lord, and by causing question.
In which IA?
This recent IA, my lord. Yes. Due to some mistake, my lord, he was not left out, my lord.
IA number 123.
Yes, 2 days, my lord, this is 123, my lord.
You file an application, there is a notification of the registry.
Yes, sir, I'll
As
file.
notification, you file the application, we will consider it. WPC is same.
Last 25, my lord.
Wait. Last time. Last time on main phase.
What a PF for it?
It allowed to line 6.
No, deletion of the.
order.
This is copy, this is service commission. For deletion, only, keep your photo.
Six को ले notice six को लगे ready for 6 को implement कर लगे थे
No, pilot पर आपको details तो होगे जैसे over to normal this way yes sir what is it why to why के बाद
6 and 9 it
Yeah, just to do this. I know this one 6 what. 120.
I don't know but I have not received the copy.
Your lordship, it is with regard to deletion of name or respondent number 11, your lordship. Here,
I have to get the copy, my lord. I have to get the copy. I have to know something about the IA. I have to take instructions what is going on. So let's say they will directly copy today itself. The matter may come after 1 week. So that
you are for Wipro.
no, I'm for the petitioner, your lordship.
I am for respondent 3, 4.
Application for petition of the area party.
In this case, my lord, we are the PF department, we have issued notice upon them, certificate of recovery. They said that they could not pay the amount because we pro
No, there is another,
things are there.
there is a review.
Main thing is, I am
We
the
have
main
filed a
party in the
review
case.
petition, that review petition
I
has
am
not
the
been
main party
disposed
in the
of.
case. Let a copy be served upon me, my lord. A copy is here, post copy is here. After that, matter may come about 1 week. I
So this application is for deletion of the name of respondent number
11,
11.
11. It's a Wipro, your lordship. Because we have,
Yes, so what is your submission? Yeah.
My lord, I have not yet the copy of the IA. Copy of the IA is to given. They want to withdraw, they have entered into some agreement. What is that agreement? I have to know. So copy of the IA may be served to only. They will directly
Okay.
serve the copy of IA.
Okay, let it be on Monday then. You
In
serve
the
copy.
meantime, copy of the IA may be served to.
Heard, mister,
your
your
lordship,
name please?
maybe on 11th, your lordship.
Okay, your name please?
S. Dekar.
S. Dekar, learned counsel for the applicant. Mr. Sharma for respondent number, opposite party number
34678
34678
9 and 10.
9 and 10. And mister, your name please?
My lord, A for respondent number 11.
Respondent number 11. And Mr.
Property is A8, and that's respondent number.
Respondent number 8,
Respondent number 8, yes, your lordship.
NRC.
NRC.
I'm not for 8.
Respondent number 8. This application, interlocutory application is preferred by the applicant for deletion of the name of respondent number 11 from the array of the writ petition being WPC number 3411 of 2023. So Sharma submits that he has not been furnished with a copy of this application, and accordingly he prays for issuing direction to the applicant to furnish a copy of the application to the petition to him. Where allowed,
Phone number.
the
Phone number.
counsel, learned counsel for the applicant shall furnish a copy of the application to Mr. Sharma during the course of the day.
Yes, sir.
Course of the day. Okay.
Okay, I will do this.
Mr. Payeng also submits that he has also not been furnished with a copy of the application. Mr. Dekar undertakes to furnish a copy of the application to Mr. Payeng also during the course of the day. This is the matter on 11th.
Yes.
39.
What the instruction that my lord, because of one having the GST registration, the husband of the petitioner was the contractor. After the execution of the contract, he expired. Now there is a balance amount that is due to him. But we are processing it, but because of non-registration under the GST Act, we are not unable to, my lord, release it because we'll have to, my lord, make the statutory deduction under GST. In fact, my lord, the petitioner has been informed by the executive engineer in this regard. So, my lord, he may have the instruction, my lord, if at all it is possible to register, my lord.
In the year of 2002, there was, I think there is no GST
Now,
registration.
whatever bill is to be paid, it has to be there.
GST registration is required.
Yes, that is what they say, madam. So at least he may approach
So
the
the
executive
petitioner-
engineer, office of the executive engineer, and madam clarify whatever is there. Otherwise, this is the instruction that I have got, madam. We are processing it, but we are make the payment because of that. One
No,
person.
now she has to register
Yes,
under the GST Act.
yes, madam.
Now I have to register, I am a homemaker. Why I will register myself
So
under the
whatever is the legal implication, I am saying, madam, the person has expired. So let her at least approach the authority. Let it be pending, madam, the lordship will post it after 1 week. Let her approach, then they will explain it to her. If she has any grievance, she can place it before the court in the contempt case.
Your lordship?
After 1 week, let her approach the executive.
Mr. Gogo, you say generally obtaining one succession certificate, they can get the amount.
But
So if she obtain a succession certificate, can she get the amount from
my
the?
lord, on legal aid certificate she has. So there is no dispute about her authority to get the amount.
Hmm.
That she has, madam. In fact, she has enclosed it. We are also not disputing that part. Only thing is, my lord, these are statutory deduction, my lord, we'll have to deduct it. Like, my lord, TDS, my lord, in case of.
Oh, okay, you deduct it, but
Without
whatever
that
amount she is
registration,
entitled
we will
to.
not be able to deposit it before the authority. I have even talked to the tax authorities also. They say that it will have to be, otherwise, my lord, it cannot be deposited. 1% deduction will have to be there in the office. Rest of the amount, my lord, it is the contractor will have to deposit as per his returns and all. Because it is a firm or, my lord, if the individual is a contractor registered, my lord, under the PWD, that I don't know.
In fact, my lord, the tender date or the contract, that is not, my lord, mentioned in the order, post order. Only the amount of 5 lakhs is there. So whatever is the complication, my lord, later it is approached, my lord, before the executive engineer. And my lord, let it be posted after 1 week. He will know, my lord, what is the difficulty. At least it can be resolved. Otherwise, my lord, there is no dispute regarding the amount. And we are trying to help her, my lord. That's why I'm saying. 1
Your
week, my
lordship-
lord,
Your
later it
lordship
is-
kindly record their statement that says they have not dispute regarding the 5,54,000
Yes, ma'am, it is there in the court.
They are ready to provide it if she is approaching the
No, not
executive.
approaching, my lord. Later approach, they will, whatever is the, my lord, complication, whatever issue is there.
Because,
they will
no,
explain it.
because the GST thing is there, so your lordship, she is a homemaker, she does not have any income. So from where, why she would register her name under the GST portal? This is the main thing, your lordship. I am a homemaker, why should I will go to the GST and I will, register my name under the GST portal as I am receiving the money which I am entitled to receive it?
Think over the matter.
Just
Pardon, lordship.
You think over the matter.
She will not close the content, my lord. She can upload again, my lord. On next step, she will say whatever she has got the information from the executive engineer. She will place it. In the meantime, I will also try, my lord, to resolve it. After all,
No,
my lord, that amount is
Mr.
due.
Mr. Gogoi, you say, why a homemaker will get her name registered under the GST Act? In the process also, she has to pay some of the amount. She has to observe some of the formalities.
Some formalities will be there. That's why if
Then-
she approaches, she will understand, my lord, what is the document that is required. If she has any objection, she will inform this honorable court and accordingly I will act upon. At least, my lord,
Usually,
lordship can direct that without this.
No,
will have-
Mr. Gogo, you say, usually,
Yes, yes.
this legal hair certificate or the succession certificate is the best course of action
Yes, yes.
in getting the amount.
My lord.
So you explore that possibility?
Lordship, I will intimate them, my lord.
Hmm.
Because, my lord, that is there in the contempt petition
So
also.
the thing is that you cannot compel her to get her name registered under the GST Act.
Good.
That is there. That is there.
Because
On the other hand, she has the right to receive the amount.
amount is being the legal and amount
Yes.
is due.
Yes.
My lord.
Okay.
So let it be
You
after
go
7 days.
and meet the executive engineer there.
Your
Then-
lordship kindly fix a date, your lordship.
Yes,
No, we'll
let
fix
me-
a date.
And your lordship kindly record a statement that they are ready to provide this amount, your
Yes, yes.
lordship. That
My lord,
is- at
demand
least,
proposal, this is the amount, my exact amount. Lordship may record that. Demand proposal also have been submitted.
because this matter is pending, your lordship, since 2024.
No, this
No, that
contempt
the
case
writ
was
petition.
registered in
You read that
2025.
read petition, your lordship.
Lordship will see the amount, my lord.
54,000.
Okay. Heard, miss, your name please?
As me, your lordship.
S. Bhuya,
Yes.
learned counsel for the petitioner and Mr. Gogoi for the contender. During the course of hearing, Mr. Gogoi has produced one letter dated 14/9/2025 issued by the Commissioner and Secretary to the Government of Assam Public Work Department, Public Work Road Department, Dispur,
My lord.
to the Commissioner and Secretary to the Government of Assam Judicial Department, Dispur. In respect of demand proposal for an amount of rupees 5.54
Yes.
thousand and 751 within bracket L against the against the court case being WPC number 1056 of 2023 filed by one Pawan Jyoti Neug. Pawan Jyoti Neug. Mr. Gogoi, on the basis of said letter, submits that the contemptor is ready to make payment of the amount. However, the petitioner has to register herself under the GST Act and she has to, no, only then the amount can be paid. However, the learned counsel for the petitioner submits that the petitioner is a homemaker and why she should register herself as and register herself under the GST Act.
বাকি এমাউন্টটো তোমালোকে আন্ডাৰটেকিংটো নিজে দিব লাগিব।
At this instance, Mr. Gogoi submits that that is the only way to make payment of the aforesaid amount. And under such circumstances, such circumstances, it is provided that the learned counsel for the petitioner shall obtain instruction from the petitioner and apprise this court on next day.
Yes.
And in the meantime, Mr. Gogoi shall also explore the possibility of payment of the aforesaid amount on submission of either legal heir certificate or succession certificate by the petitioner to the executive engineer of
Executive Engineer PW Sibsagar Demo Territorial Road Division.
PW Demo.
Sibsagar and Demo.
Sibsagar and Demo.
Territorial Road Division.
Territorial Road Division, Sibsagar and Demo. Demo. List the matter on
Any day convenient person.
13th. The letter produced by Mr. Gogoi shall be marked as annexer A and B, annexer B and be tagged with the record.
Oblige, your lordship.
Item 40.
Last negative.
Yeah, please, your lordship. Your lordship, earlier in WPC number 570625, lordship, wherein honorable court directed me to file an amended prior portion, lordship. Accordingly, lordship, I have filed an IA being number 3948, and thereafter honorable court allowed us to file an amended read petition, lordship, for the with a prayer to amended the prior portion. Only because of that, lordship, previous occasion, lordship, we have filed a representation before the ombudsman, being aggrieved non-consideration of our representation by the Bajaj Alliance Insurance Corporation, lordship, wherein my husband working into their company, lordship, but he died in a road accident. Therefore, I am eligible to get certain compensation, but our representation could not be considered by the Bajaj Alliance. Being aggrieved, lordship, we have filed a representation before the ombudsman, lordship. The last page of our representation, your lordship, annexer page number 40, annexer I, your lordship.
No, you have filed IA.
Yes, lordship.
IA is not put up before the court.
Another coordinate bench of this honorable court, lordship, with a prayer to amended our prior portion, lordship, wherein earlier read petition,
That was allowed.
yes, lordship, that was allowed. Honorable court order dated 15/12/2025, lordship. And thereafter, lordship, amended read petition I have filed, lordship. Amended read petition we have filed only for the amended the prior portion, lordship. Sought for direction to the ombudsman to dispose of our simple representation, lordship, which was not considered by the ombudsman.
No, whether that amended application is put up before this court.
Your lordship,
Your amended petition is put up before this court?
yes, lordship.
When?
Lordship, we have subsequently filed our amended read petition, lordship, maybe on record, lordship. Amended read petition.
No amended read petition has been filed. No, you have not filed it.
We have filed, lordship, amended read petition, lordship, maybe on record, but it may not be I'm not sure about. Because I amended
There
it
is an
for-
office note, in the office note, there is no such order. When did you file?
Lordship,
When?
Lordship, we have forgot the exact date, but prior to 10 days, Lordship, we have filed Lordship. Amended writ petition, Lordship, but I am not sure it was not on record, Lordship.
Okay. Heard,
Raise the
Mr.
direct-
M. Soikia, learned counsel for the petitioner. Mr. Soikia submits that person to order of this court in IA number in IA number
394825.
3948/2025. The petitioner has already filed amended writ petition. But
That is filed on 22nd January 25.
22nd January 2026. 26.
Or 26.
But the office note dated 3/2/2026 indicates that no amended writ petition has been received by the section. Accordingly, it is provided that registrar shall raise the matter on Monday. And also the registrar shall put up one up-to-date office note in respect of the amended writ petition being filed by the petitioner. Monday, you go to the section and confirm.
No,
it. Over.